recognize each speaker one at a time. When it's your turn to speak, please introduce yourself with your name and any organization that you may represent. Each member of the public will have 3 minutes to address the Board of Commissioners. Please be aware that the Board of Commissioners, each of us, care and are eager to hear from you. However, as a body, our job is to focus on listening to what you have to say as opposed to engaging into an individual dialogue with the speaker or making comments on your comments. With that,
I am not here officially today with any organization, but I am also a journalist with the Rapidian out of Grand Rapids, which documents public meetings. I have recently filed a court of claims action regarding the derelict of duty of bar members against the Judicial Tenure Commission and the Attorney Grievance Commission. I am asking the Michigan Supreme Court for relief because of the monopolization and the usurpation and violations of separation of powers and unclean hands. The evidence that I have filed is very self-evident and shows that bar members are very aware, the commissions themselves, of them violating their canons, their ethics, and professional conducts and duties to such a degree that it is jeopardized our judicial system and the integrity of it, and it's quite embarrassing and it's inefficient to our branch. So I'm asking for superintendent control for my legislator to come in into the internal aspect of the judicial branch and have transparency for oversight regarding those matters, since it is very obvious that you cannot do it yourselves, which is just very embarrassing. Regarding the state referral service on your agenda items, I do oversight also in advocacy, and I've engaged your referral service because I was seeking representation for tenant issues. You have no attorney on your referral service that represents tenants, and also when we go to call law firms or lawyers, they tell us they've been told that they only can represent owners and businesses. They do not and will not represent tenants, and therefore when we have legal aid services that do not provide enough or adequate representation, which I've done advocacy in Kent County and got a full-time attorney for evictions and foreclosure issues, most recently this past year, and it's just clearly obvious the monopolization, the blocking that has been created to keep pro se or pretty much anyone of the public from having real justice delivered to them. So when we have one-man grand jury still on the books today, when the United States Supreme Court over 75 years ago said it was unconstitutional in Michigan, that is embarrassing.
Currently, I've been involved for many years now with various types of court cases. And to date, since 2010, I've disqualified 13 judges. One you probably are well aware of, and that's Teresa Brennan out of the 53rd District Court, Livingston County, where she was removed, disbarred, and went to jail. Currently, I am disqualifying another judge by the name of Daniel B. Bain out of that same district court. I have transcripts where he has announced on and for the record that he is acting as prosecutor, judge, and jury. I have him coming out from behind the bench, belittling my court watchers, and acting completely unprofessional. And over the years, I've noticed that your grievance commissions and such are a joke, because we have filed numerous complaints against judges and they all come back with the same response. Can't find anything wrong. And that includes Judge Brennan. We filed numerous complaints against her, all came back the same, but yet she was removed. So there's proof that your grievance commission doesn't do the job. Currently, there are issues now, but with Bain, now have him before the federal courts, federal district court. And he has no, and I have been able to pierce now the judge's immunity clause because of his actions. One of the other issues that you guys better take note of is the fact that I repeatedly asked for to see a license. There is no such thing as a license to practice law. What state department or agency issues that license? According to a certified response from the Department of Licensing and Regulatory Affairs, there is no such thing as a license to practice law. Practice of law is a common right that we the people have. Further, we are not contractually bound by your court rules. Never have been, never will be. So when we're in court litigating and you don't like the fact that we take longer in the court than what you like, well, you know what, that's our right. We have the right to air our grievances before a competent court. But the problem is we don't have courts, we have administratives. Because under Article 6, Section 19 of the Michigan Constitution, to be a judge, you have to have a license to practice law. And that doesn't exist. The U.S. Supreme Court has ruled on this, that a bar card is nothing more than a union card. It's a membership card. It is not a license. So,
Thank you very much for your comments. Your time's up. Is there anyone else, a member of the public?
A few years ago, one of my friends here, Jody White, and myself, and a couple other women from the Detroit area attended Michigan Senate Judiciary Committee, then chaired by Senator Pete Lucido, regarding a bill designed and put forth by Senator Jim Runestad to create guidelines around producing and distributing video and audio recordings of proceedings in Michigan courtrooms. The bill was laden with a lot of unreasonable stipulations. Judges insisted that they may not even want their proceedings recorded. They insisted that they didn't have to recognize what was actually recorded as being part of what they would consider the official version of the court proceeding. And rather than these things that I pointed out being corrected, I found the bill was completely shelved by the committee, apparently at the insistence of some judges who had Senator Runestad's ear. He later conveyed that they told him, well, we don't want to be recorded, we don't want to look bad. Now, I have found by looking at some research done by a woman named Samantha Hallman, which I believe spoke here not long ago, that the Michigan State Bar claims to have had the desire to see the implementation of policy providing accurate electronic records of court proceedings to the public for the sake of courtroom transparency since 1987. Now, the details of MCR 8.119, Senate Bill 257, 10 points listed in what I saw referred to as Attachment A in the discussion you had, they all seem very good, most of them anyway. Why have they not been put into practice? Apparently there is some debate about whether the judiciary should be responsible for seeing that our right, and different courts have claimed that it is our right under common law and the First Amendment to have these recordings. It's never been implemented, and I guess you're debating whether you should do it or the legislator. I say you're all responsible. So hopefully you can work together on it. You know, Michigan is the only state in the 6th district, which also includes Ohio, Kentucky, and Tennessee, that does not make electronic recordings of court proceedings available to the public. They all do and have for a while, and we don't. So I'm asking you to please, finally, give us what we have the right to, give us what we're entitled to, quit making us rely on these written transcripts, which are often selectively edited for the sake of not incriminating the judge at hand. And I've experienced that personally. They're also a nice little side business for some selected judge's favorite clerk in the court, it seems, because they're expensive. But please work and finally put this in practice out there and make them provide. Quit asking these judges who say they don't want to look bad if they want to agree to their court recordings made available to us or not. We have the right to it, and it's been said by people that you would consider more authoritative than than us.
But my comments here today is with this commission, is that after looking through the commission list, there's at least 3 judges and assistant attorney general who works for a public functionary. So these 3 judges are elected public functionaries, and I hired them by my vote. And they have an oath of office to the United States Constitution and the Constitution of the state of Michigan. The question I have here is that upon entering that office and honoring that oath, they need to have their bar card membership rescinded, terminated until they leave office, because they owe that oath to me, the public. Okay, they can't be here sitting on this commission. Okay, their job is to judge. They elected that. They did that on their own. When they came into the public arena, they belong on the bench. They don't belong in this committee. If they have a grievance, a commission, or they have issues, they can put it in writing and send it to this board for review. But they don't belong on this board. I hope today that if there's any judges here, sitting here, that they took a vacation day, because my public tax dollars didn't pay that judge to sit here in your private membership association. It paid for them to be sitting in whatever court that they belong in 5 days a week and take their vacation days, and if they want to use them for whatever they want to do, but they don't belong here, okay? Number 2 was that the second thing was about this protecting these judges. Now, as all these 3 judges on this commission know, they had to give away all their public information to become an elected public functionary. If you've ever ran for any office, you have to list everything about your family, where you live, your background. It's all public record. So this is all nonsense. And you guys agreed to say these judges get special immunity. Now, if you want to become a judge, you take the risk involved in that. You better do the right decisions. And of course, there are extenuating circumstances, and that's where the sheriff comes in. If you got some issues where you think your life might be in danger, I understand in some of these hard criminal proceedings that might be possible. All right, so then the last thing is that, you know, with these judges who have a membership card sitting on the bench, and I've witnessed this, is that they create barratry with their other fellow bar card members to defraud the public. And most of this arena is happening in what we call this probate court in Michigan. And so the goal is they're trafficking high net worth families and robbing their assets. I've seen these judges and these attorneys embezzle trust assets, embezzle federal VA benefits from people, and nobody cares. The issue is that there's no oversight to any of these judges, ever, anywhere in this state. Nobody reviews their decision. After they make it, there's no higher level that goes in and says, you know something, that judge can't do that.
So thank you for the opportunity to speak today. My name is Jody White from Livonia, and I'm here to address serious concerns about probate court abuse in Michigan. For the past decade, numerous bad actors in our probate system have caused significant harm to Michigan citizens. Particular concerns are former county public administrators in Oakland County who operate, as you guys probably do know, under the state public administrator and the Department of the Attorney General, the club. These individuals, identifiable by their state bar membership and their P numbers, have been involved in some troubling practices that deserve scrutiny. The scope of this practice is vast. Estates are being depleted, legacies destroyed, and families traumatized by certain probate attorneys who mishandle our assets and our loved ones. While we can identify the 103 probate judges serving our 83 counties, the thousands of victims of these practices often remain voiceless. Let me share one specific example from my family's experience. In 2012, Adult Protective Services alerted Judge O'Brien about David White, who was recently convicted by a jury in November of 2024. A couple people in this room know who David White is. He has been convicted of conducting a criminal enterprise, embezzlement, and tax evasion. However, the broader system of accountability has failed us. Attorney Frazier, and I can name his name because it's all a public record, he was court appointed as a special fiduciary in 2012 to monitor the John Sterling White estate in Oakland County, but failed to fulfill his fiduciary duties. when we attempted to subpoena bank records in 2016, some attorneys, Frazier and a couple other ones here, actively worked to block our efforts. In September 2018, after paying for the Court of Appeals, it was determined that probate judge Daniel O'Brien wrongly denied our family a jury trial and continues to harm our 12-year estate. 12 years we've been in Oakland County, 12 years. The Prince Law Firm who was involved in these initial proceedings have left Michigan without being held accountable. Have paid for. Despite multiple complaints filed since 2018 with the Attorney Grievance Commission, the Attorney General Commission, the State Court Administrator, the County Commissioners, the Probate Administration, and our state legislators, Assistant Attorney General Scott Teeter has chosen to prosecute only one of the co-trustees, co-trustee B, while ignoring the professional attorney role in the matter, the special fiduciary co-trustee personal rep, co-trustee A, Thomas Brendan Frazier. Our family's case exemplifies a broader pattern. The State Bar of Michigan's disciplinary branches, the JTC, the AGC, the ADB, the Attorney Discipline Board, okay, have remained notably silent. Meanwhile, attempts to access courtroom videos of these proceedings have been blocked, while State Bar members appearing to prioritize professional protection over public interest.
Thank you very much.
We want our videos to prove our complaints. I have one more paragraph.
Let me
May I
just say, I will not speak, and I'm gonna piggyback off her. It's the same subject.
Well, I only have 3 more sentences.
And if she could just finish up.
Thank
All right,
you,
I will
Jeff.
not speak.
That's
Yep.
my husband, Jeff White, so, he should be able to speak, but if you can time me and he can have the rest. Thank
I
you, sir,
don't-
I appreciate it. Today, because there's the challenge, I'm challenging all the leadership here of the State Bar of Michigan as representatives of our 7 Supreme Court justices to join a citizens task force. There's 11, 12 of us here today. There's more, but only a few can come during the middle of the day. We need to address the Attorney General's selective prosecution policy that allows some attorneys to operate with impunity, negligence, and criminal behavior. I specifically request a board member from the State Bar to attend the upcoming sentencing hearing in Oakland County on February 20th for co-trustee B. The sentencing is only the end of half the issue, as we wait to see how the Board of Commissioners will look into the behavior of the probate attorney and the prosecuting attorneys with the John Sterling White criminal conviction of November 2024. Remember, we've been in it since 2012. We need some help. In closing, if proper investigation had been conducted through the Attorney General's office, or if we would have a properly functioning Attorney Grievance Commission and Attorney Discipline Board, many of today's speakers right here would not need to be here, because we're from 18. We've actually been since 2012, complaining since 2018. I await a timely response, and in closing, we have some letters for the Board of Commissioners. One is for a request for intervention, one is because of your authority and obligation to intervene, and then we have a legal foundation and specific advocacy efforts, which I love all the stuff that you guys are also doing, but we'd like to put probate court as one of them for 2025. And we have a Michigan Attorney Fiduciary Accountability Bill of 2025 that, we're working together to draft, because no attorney should have multiple roles and harm what they've done to our family.
Thank you for allowing me to speak today. My name is Cynthia Mifsud. I'm here to address urgent concerns about attorney conduct and oversight in Michigan guardianship cases, illustrated through my family's devastating experience. In 2013, my mother, of sound mind, designated me as her durable power of attorney and healthcare proxy. She also named me trustee of her trust. These were properly executed legal documents created specifically to avoid future probate court and guardianship proceedings. Yet in 2021, when my mother needed these protections most, they were effectively nullified through a series of legal missteps and questionable attorney conduct. They hid my mother's trust in probate court, just acted like it never existed. What followed was a 3-year guardianship battle that should have never happened. During this time, my mother suffered 2 bouts of sepsis, a broken foot, and ultimately a catastrophic stroke. Our family lost precious time with her that we can never recover, while simultaneously, my family, my personal family, spent over $200,000 in legal fees. The guardian ad litem, after I was appointed guardian finally, after the 3-year battle, billed the estate $50,000, and the court-appointed attorney billed the estate $68,000. My mother needs 24/7 care, and her estate was only worth $146,000. So, how was she supposed to pay and live off of anything when they're trying to take all of her money? The Michigan Attorney Grievance Commission has opened a file based on my complaint which details multiple serious issues. First, despite having a valid legal instrument in place, our attorneys failed to properly defend these existing rights. Instead of enforcing the DPOA in civil court, they pursued an unnecessary guardianship petition, creating a complex legal maze that served no one's interest except those billing hours. Second, we were never properly advised of our legal rights or appeal options. Critical deadlines were missed. Strategic decisions were made without proper consultation or explanation. Third, and perhaps most troubling, was the apparent collaboration between attorneys to prolong and complicate proceedings rather than resolve them efficiently. These issues point to serious systemic problems in how Michigan oversees guardianship cases. We need stronger protections for existing legal instruments like DPOAs, better oversight of attorney conduct in guardianship cases, clear standards for billing practices and transparency, swift consequences for attorneys who exploit vulnerable families. The Michigan Bar has a crucial role in protecting families from experiencing what mine did. Every day this system remains unchanged, more families are at risk. I'm not here merely to share a personal grievance. I'm here because the system needs reform and because other families deserve better. The Bar must take more active role in oversight and enforcement.
Scarborough, thank you for letting me speak today. I'm from Macomb County. And just have this issue with the probate also. Between April 22 and February 23, a series of concerning events unfolded in Macomb County Probate Court. I'm here to detail these events and request your intervention. On April 18, 2022, a 9-minute probate court hearing occurred without my knowledge, where false statements were made about my character. And by May 15th of 2022, a 6-minute hearing followed, where an adult protective services agent, their attorney, guardian ad litem, and attorney, Terrence Gilsonen, initiated proceedings affecting my fiancee, Judy, who was deemed a vulnerable adult, and myself. These actions resulted in Judy's forced placement in a nursing home and our separation. And just a little history, we've known each other since the first grade, me and her. And despite being assigned a court-appointed attorney to protect her civil rights, no meaningful advocacy occurred whatsoever. I retained 2 attorneys myself, and neither reported potential misconduct to the appropriate oversight boards, such as the Attorney Grievance Commission's Attorney Discipline Board, or the State Bar of Commissioners. The court proceedings led to my imprisonment twice for trying to help her when her family didn't want nothing to do with it. That's how this Terrence Gilsonen got involved in the first place. And in which that first time I was in jail for 21 days, our home was cleared out and the locks were changed. And then in February 23, they facilitated the sale of our home. Throughout this process, Attorney Gilsonen collected over $60,000 from the proceeds of our house sale, which I had shared with Judy since 2012. Despite attempts to seek justice through the proper channels, including the Sheriff's Department, the Prosecutor's Office, my evidence was held for 9 months without action. Prosecutor Peter Lucido responded with a cease and desist letter, and subsequent interactions raised further concerns about professional conduct. Now I ask you as Michigan Board Association here to have the authority to recommend reforms to protect Macomb County residents from predatory practices. We need 1, mandatory oversight of our court-appointed guardian ad litems, guardians, conservators, and attorneys' billing and activities, and prevention of forced separations and isolation without due process. Investigation into retaliatory practices against those who speak out, which had happened to me twice. And implementation of checks and balances in the probate court system, and document the written complaints provided to the probate administration in Macomb County. Now, this isn't just about me and Judy, it's about protecting every vulnerable resident of Macomb County and the state of Michigan for that matter. And the separation of loved ones, the sale of property without consent, and excessive legal fees must stop. Please exercise your authority to recommend changes to the Michigan Supreme Court and support reforms in our probate system. Our seniors and vulnerable adults deserve better.
Good afternoon, my name's Lori Loma. I stand before you today after a 7-year journey in probate regarding my mother. Her bank account and her Wixom condominium that her and I shared together since 1993, which we purchased together. Before coming to Lansing, I visited the State Bar of Michigan's website and was struck by your purpose statement, which reads, "The State Bar of Michigan shall aid in promoting improvement in the administration of justice and advancement of jurisprudence, in improving relations between the legal profession and the public, and in promoting the interests of the legal profession in the state." My personal experience in Oakland County, which I have my own personal story going. Okay, where my deceased mother and I fell victim, like I said, probate creditor playbook. I discovered that judges and attorneys in probate courts are systematically failing to follow the rules of civil procedure and judicial canons. This isn't just happening in Michigan, it's a national crisis that demands our immediate attention. I join forces today with other concerned citizens who seek answers from this board. We need a new legal theories and methods to effectively oversee these probate proceedings. I mean, it's absolutely horrible, horrible. So I suggest that somebody kind of help us and work with us on this. I'm almost ready to be homeless. And it's not fun. When you purchase the home with your mother and lived there for 30 years. I'm mad, that's why I get scared. Yeah. And when you have a brother who's pulled $1 million. Well, you know who the judge was. Kathleen Ryan. So that tells you what kind of person she is.
And I'm representing myself, but I'm with the group, and I'm also a victim, as well as my mother, so I'm actually fighting for my mother. I can sum this up. I can relate to everything they're going through throughout the counties. This is a systemic issue through Michigan. So on behalf of Kent County and all the counties that came before me, I would like to conclude our meeting today by expressing our strong interest in establishing a collaborative partnership with you all. We believe that by working together, we can effectively address the challenges we've identified and foster a productive and mutually beneficial relationship. This partnership will provide a structured framework for identifying areas needing improvement, strengthening communication, and building stronger relationships between the State Bar of Michigan and we the people. Through open dialogue and shared expertise, we can collaboratively develop effective recommendations and implement solutions. Our goal is to transition from a potentially adversarial us versus them dynamic to a collaborative approach focused on a shared success. We believe this partnership would offer a significant opportunity to achieve this. Thank you again for your time and consideration, and we eagerly anticipate the opportunity to work with you all in the near future.
Thank you. Anyone else in the public?
I just had a question, if I could.
This is not an opportunity for question and answer.
It says questions to the commission. My question is this: you were talking earlier regarding judge disqualification under the court rules. And my question here is, rules are not laws. And under Title 28, Section 455, and according to the Seventh Circuit ruling of the Taylor v. O'Grady in 1989, upheld by the U.S. Supreme Court in 1994, the judge will find that the possibility of impropriety exists and the possibility need not be proven, just that it may exist, and that no motion or affidavit needs to be filed. How is it that we have judges, when we file a motion for disqualification, rely strictly on the court rules and refuse to follow the law? Which comes first, the rules or the law? And I've asked this question repeatedly before judges and before disqualification issues, and they always fall back to the court rules as the dominating factor in determining disqualification. Are we here to follow the law of the land, which is the Constitution, or are we here to follow rules created by a committee?
Marbury versus Madison.
And are you familiar with North East Shelby County of 1886? Because I highly suggest everybody get in tune with that and take judicial notice of it. especially considering US v. Trump in the Florida case, where it was decided that special prosecutor's office is de facto. Now, in order to be Shelby County, no office de facto can be created. So, food for thought. And I'd like to hear an answer to that question.
Sure, here's your answer. Thank you very much for your comments. As President of the State Bar of Michigan, I can speak on behalf of this Board of Commissioners, and I want to assure you all that we appreciate your time and your willingness to join our meeting and to share this information. As a reminder, the State Bar of Michigan is not responsible for the discipline of attorneys or judges. The State Bar of Michigan is responsible for licensing Michigan attorneys. Rather, the Michigan Supreme Court is the entity that solely makes the rules with respect to the practice of law and what judges do on the bench. So, thank you very much for your comment.